I'm Lyles Williams, Chairman of the Mississippi Workers' Compensation Commission. I'm here to talk with you about the 2012 changes to the Workers' Compensation Act. While my talk summarizes the changes in the law, it is not intended as legal advice. For legal advice, please contact an attorney to find out how these changes may impact you. You can also read the changes to the law on our website. The Workers' Compensation Act is the body of law that governs the payment of workers' compensation claims. During the 2012 legislative session, the legislature made several changes to the Act. These changes apply to all workplace injuries that occur on and after July 1, 2012. There are 8 major changes that I will briefly talk about. Change number 1. The Workers' Compensation Act has long stated that it will be fairly construed according to the law and the evidence. The law now states that it will also be impartially applied, that the law will not favor the worker over the employer or the employer over the worker, and that the law will not be interpreted to fulfill any beneficent or goodwill purpose of the Act in order to favor the worker. Change number 2. The Workers' Compensation Act has also long stated that its purpose is to prevent injuries, restore the worker to health, and return him or her to work. The law now states that the purposes of the Act are also to 1. Timely pay disability benefits in legitimate claims, 2. Pay reasonable medical expenses that are related to the job injury, and 3. Encourage the return to work. Change number 3. A petition to controvert is the document that an injured worker files with the Commission to begin litigating a claim. Now, if no benefits of any kind have been paid, the Act requires the worker to file 1. A petition to controvert, and 2. Medical records in support of the claim. But if the statute of limitation or deadline to file a claim is about to run out and the worker does not yet have any medical records, the worker can file the petition to controvert without the records and still have 60 days to file the medical records in support of the claim. Change number 4. In recent years, injured workers who had a pre-existing disease, handicap, or other problem did not have their benefits reduced because of the pre-existing problem unless the pre-existing problem was occupationally disabling. The law now states that the pre-existing condition does not have to be occupationally disabling for the employer to ask that the benefits owed to the worker be apportioned or reduced because of a pre-existing condition. Change number 5. The legislature has amended the law that governs the injured worker's right to select a doctor for medical treatment. It is still the law that the injured workers are entitled to 1. Pick their own doctor to treat their work injury, or 2. Accept the doctor selected by their employer. But the new amendment states that any doctor who has treated the worker for an injury for longer than 6 months or who has performed surgery on the worker because of the injury will be considered the worker's chosen physician. Change number 6. The amendments also increase the amount of benefits paid to an injured worker in these instances. If a worker has a facial disfigurement because of a work injury, for an example, a permanent and serious facial scar, he or she can now recover up to $5,000 in benefits because of the disfigurement. If a work injury results in death, the surviving husband or wife will now receive an immediate payment of $1,000 and a $5,000 payment for funeral expenses. 3. Any injured worker who is enrolled in a vocational rehabilitation program is entitled to $25 per week for a maximum of 52 weeks. Change number 7. The intoxication of an injured worker at the time of the injury has always been a defense to a claim, but the legislature has made some significant changes to the laws regarding this defense. First, intoxication now specifically includes not just intoxication from alcohol, but also from the presence of illegal drugs or even prescription drugs if taken in a manner other than as prescribed. Second, employers can require every injured worker to submit to drug and alcohol testing after a work injury. Third, if the drug and alcohol test comes back positive, then the burden shifts to the injured worker to prove that the injury was not related to the presence of drugs and/or alcohol. Fourth, if a worker refuses the drug and alcohol testing, then the law will presume that the injury was due to the intoxication. The law defines the legal limits of alcohol to be 0.08%, but it does not define how much of any drug found in the drug test is enough to trigger the requirement that the worker prove that the presence of drugs was not the cause of the work injury. Change number 8. The Workers' Compensation Act has long stated that a worker's attorney may receive up to 25% of the total award of compensation as an attorney's fee. A change to that act makes it clear that attorney's fees cannot be paid from benefits that are voluntarily paid. However, settlements of compensation claims will be subject to attorney's fees where an injured worker has hired an attorney. The Mississippi Supreme Court recently ruled that appeals from the Mississippi Workers' Compensation Commission will bypass the Circuit Court and go directly to the Mississippi Supreme Court. This change will hopefully shorten appeal times and allow cases to end sooner. If you have any questions about the changes to the Act, please review the information on our website or contact an attorney to find out how the changes may apply to you.